Hi, great to see everyone. I'm going to stop sharing for just a sec so that I can see everybody. Um, you know, every time I do this, Nina, there's so many buttons coming up on Zoom that I just wanted to say hello. And you know what I'm going to do? I'm going to also get the transcription going, so we might have that as well for future reference. And yeah, hi, happy, what day is it? Thursday. Oh my gosh. I
Yes.
love having these sessions on a Thursday, actually. It just feels like a nice way. It's like the gateway to the weekend. You can
Yes,
consider this session.
absolutely.
But I know we have a lot to get through. Thank you so much for being here. I'm seeing so many familiar face or names up there. I don't know if you're looking at the
I
chat,
am too. I
Nina.
always look at who's
Uh,
coming to my party.
yeah, I
Yeah,
see
for
John,
sure.
Emily, Nicoletta, Amy. So
Yeah.
it's so great to see. I'm sorry I can't mention everyone, but it's so wonderful to see you all. And I am going to share my screen now that I got to transcribe and I see everybody. I'll share it. And just so happy you're all here and happy Nina's here and that Nina and I can make this into a tradition now. We did it last year. We closed off the year and kicked off 2026 with this. So I want to wish everyone a very happy holiday season and remind you that there are only, if you do celebrate Christmas, I assume some of us do on the call, that there are only 20 days shopping days left. So when you're done this webinar, you better get out and start shopping. So I just started mine this week. So listen, I wanted to just quickly, for those of you, there's so many new people here today as well. I just wanted to quickly introduce First 30, which is a business I run. We do more than outplacement and career transition, but we do a lot of outplacement and career transition as well. And I wanted to just say that what some of the things that set us apart, if you're considering this type of service, I'm always happy to talk to you, answer questions. There's never any pressure. But if you're just curious about what we do, we are very differentiated in a few ways, all the same services you're used to, but our participants have the opportunity to meet with their coach almost immediately. So we don't have long wait times. We think that's really important. We realize that people want to be treated like an individual, and it's not a formulaic approach. We really meet them where they are, and we're very good at listening first. And our resume reviews are comprehensive. We record the review with their marked up resume. We match it to a job ad. They get their marked up resume and job ad back. This is a very tough job market. I'm sure all of us on this call know that. And anything that companies like First 30 can do to make things better, the better for everyone, for our employer clients, but also for our participants. If you're looking to spend money at the end of the year, we do offer pre-purchased outplacement bundles that you can use next year if you want. To work with us, you can review our brochure. I'll send that out to you after. Watch a 3-minute demo and then click. You can now generate a personalized outplacement letter and add participants. So now I make the joke, Nina, my clients don't even have to talk to me. Hopefully they want to, but when you want to add people, you don't even have to talk to us if you don't want to. So the last thing I'll say is 2026, I'm really excited about because we're introducing HR ready tools, which is going to be a site where there's going to be free resources and then some resources that you can pay for your organization. We're going to make it super simple for everyone. We are finally back on track with our onboarding buddy launch. So we have an AI tool to help onboarding your employees, like a little chatbot they can ask any question. And what I'm most excited about is this series has been so wildly successful that we've decided to start a Coffee and Law podcast. Now, Nina is going to be she will be probably our inaugural guest. We will be having her a lot. So I'm very excited about that if she can make it. Um, but I'm be launching that in partnership with HR Law Canada. So I'm really looking forward to that next year. Now, getting on track for the session is being recorded. So if you're going to put up in the chat, can I get it? Yes, you will get a copy next week. So don't worry about that. If you don't see it in your inbox next week, you can always message me. Now, this I would really ask. There is a Q&A tab on your panel. I would love for you to use that just because we have over 100 people here right now with more joining with every minute. So if you could use that, and the shorter, more generic questions are usually the easiest to cover than detailed, highly specific situations. If you write something very long, it's going to be really hard for me to communicate that. So you'll be able to see that there's a Q&A. Hopefully you can see that. And maybe someone can direct you in the chat if you can't. But with that, Neena, it's so great to see you as always. You're dressed for the Christmas season. I
I
know, I'm not saying
am.
everyone, but the holiday season you are dressed for
And
right
then I've
now.
got, then I think this is a seasonal item, but it's the Canada Dry cranberry ginger ale. So it's my
Yeah,
little weakness. I'm not
yeah,
much of a drinker, but that is my weakness. So that's
yeah.
my,
Well, I know whenever I come to your house, you have wonderful mocktails, which I always very, very much enjoy. But I'm going
yes.
to remind you of your disclaimer now, Neena.
Okay, so I'm going to go to work. Amy's putting me to work. So first of all, this is generic advice, and particularly we're going to be talking a little bit about pay transparency, and we are in its infancy. It comes into effect January 1, 2026. And so we're giving you high level sort of education about legal changes, but this is not legal advice. The Law Society of Ontario does not allow me to give legal advice unless I have a retainer and know my client and do a conflicts check. So I can't give you legal advice, much as I might like to. So if you go to the next slide, I wanted to just do a quick recap about some major changes in 2025. And this is really Ontario specific. The first one was serious illness leave. Now, some of us, and I recognize a whole bunch of names on the participants list. Remember, there was always an anomaly in the ESA whereby people could get leave if they had a family member who was seriously ill or there was a bereavement, but they couldn't actually get beyond very few sick days leave for themselves. So this change in 2025, next slide, actually intends to remedy that. So there's a June 19th, 2025, there was a new section 49.8 put into effect. If you have 13 weeks of continuous service, you get unpaid leave if you cannot perform your position because of a serious medical condition. And this can include chronic and episodic illnesses that are serious. Not a lot of guidance as to what constitutes a serious medical condition, but at least there's something there for job protected leave. Next slide.
Neena, I wanted to just add here that I came to your your update a few months ago, and I really did love how your team talked about asking for documentation when these things come up. So I'm sorry if I'm saying something,
No, it's a
but I
great.
do think that was a really great point for HR leaders because sometimes we'll shy away from asking for the backup, but in some cases you really do need that to do your job. It can feel cold, but it's important.
Yeah, and people sort of look at it saying, "Well, you don't trust me." Well, it's not that I don't trust you. So doctors are busy and they normally write that one line on a little prescription pad. That does
Mm-hmm.
not help you plan from a workforce planning perspective, right, Amy?
Mm-hmm.
Do I need to hire a temp? Do I need to reallocate duties? Do I have to turn down a client? You have no idea because it just says Amy is away from the office due to a legitimate medical illness, will be reassessed in 4 weeks. Well, that doesn't tell me
Mm-hmm.
anything.
Mm-hmm.
So if
Yeah.
you go into the next slide, this is job protected leave. This is up to 27 weeks in a 52-week period, and it resets every 52 weeks. Now, this may have to change, quite frankly, because I can imagine somebody who has a chronic episodic illness and you can't really manage someone who is constantly absent. And they also may have issues because they may not qualify for short-term or long-term disability because they don't, like they've exhausted those options. They certainly, after a while, will not qualify for EI because they may not have enough hours
Mm.
qualify for EI. So we are in early days of this long-term illness leave. Absolutely, you can ask for notes, you can ask for prognosis, i.e., and restrictions. So when will this person be able to come back? Can we accommodate? Are there some restrictions? What you're not, unfortunately, entitled to is diagnostic information. Although, ironically, you are entitled to know generically what the condition is. Is it a mental health issue? Is it a lower back injury? Is it a, post-surgical, consequence? So there can be some general information, but you are not entitled to a diagnosis. Is it cancer? Is it, obstructive bowel disorder? You don't get to know that, and you don't get to ask that, so don't. So if you have handbooks, you should,
Sorry, should I
oh,
go
we're
back?
good here. We're good here.
Okay.
Don't worry. If you have a handbook, you should, and you list all the leaves. I have stopped doing that because I'm lazy and they have so many leaves. I tend to focus on the paid leaves the company might provide and then indicate that there are a number of statutory leaves that the company will honor, including, and I just list them. You might want to add serious illness leave if you are operating in Ontario, and then we will see what happens. Perhaps we'll do a year end next year and see if we have more guidance from the government.
Well, it's a tradition now. We'll be
It's a
doing a year end.
tradition, but
Yes.
yes, me with my cranberry ginger ale
Yes,
and
yes.
as opposed to coffee.
This
And
this segment is sponsored, everyone. No, I'm
yes,
just kidding.
yes, exactly. We'll have to see if the ginger ale manufacturer wants to put in a plug. All right, next slide. The other thing that changed is child placement leave. And this was really to try to bring adoptive parents on par with a birth parent. And I won't spend a lot of time on it, but essentially it expands the leave that is available to an adoptive parent or a foster parent. And I think the point was, yes, it's true. Birth parents have physical consequences of birth that they need to deal with, but there is a lot of work that is needed to make an adoption placement or a new child being placed with you successful. And while it might not have the same physical consequences, it does take time. And so this really brings adoptive parents and foster parents into a closer match to biological parents. Next.
I love this.
Yes,
This feels right to me.
this feels right. And I like the
Yeah.
stork. I thought a little Susie
Yeah.
would be good for a change. Yes. And it is, so it applies obviously for adoption, but it's also if you're a couple that has had to go through the surrogacy route for bringing a child into your family, you now are entitled to that 16 weeks of unpaid leave. And I think this is generally a very good development and a family-friendly development. All right. This is my personal favorite. I know this is bizarre. July 1st. Apparently, if you're on a work site, no more filthy porta potties. Now, this sounds like such a minor thing, but it actually, there's some research done that one of the reasons women do not entertain construction-oriented jobs is honestly, those porta potties are disgusting.
This is
Like,
why I don't go to outdoor concerts
this is, yes,
anymore.
seriously, I am so prissy. Like
Yeah.
I actually took shop in high school and I was good at it. And then when we did our field trip, it was like smelly and disgusting. And it was like, well, obviously that's another career choice that Neena's not going to do.
Well, listen, we're all benefiting from the dirty bathrooms.
Yes, that's exactly. Who knows? It's the butterfly effect.
Yeah.
All right. So July 1st, not a lot. Maybe you aren't in construction, but there are times when you have temporary. Let's just try to keep them clean and remind our workers to try to keep them clean as well. I did go to an outdoor equestrian event this summer, and I was shocked how clean it was. So that was great.
Oh, that's wonderful.
Yes,
Yeah.
it was very
Yeah.
lovely. So now, most of this presentation, although some of the stuff will apply to other people, this is somebody asked this beyond the construction industry. Yes. So anytime you have a work site with a porta potty, it needs to be clean. That it's not construction oriented, although the construction industry will be the most impacted. So next, do you have more than 25 employees? There's a whole bunch of new rules. And the scariest one is document retention. Now, I have put the binders there. I realize people don't have binders
Mhm.
anymore. They're probably, but we have to do the digital equivalent of keeping binders. So let me explain. Next slide, please. Now, if you have 25 employees or more and you're recruiting, you have to retain your job postings. You have to retain all the applications. You have to keep the information you provided to those applications regarding hiring decisions, i.e., yes, no, we haven't made a decision, we've canceled the posting. And we have to keep all of that 3 years after the removal of the job posting. Now, assume that you're a retail store and you're constantly looking for good retail workers. My recommendation is you date your job posting and you keep it up for 30 days or 60 days. And then you save all of that document and you put a new job posting with a new date. And then you have another 30, 60 days and you keep all of those so that you actually don't have to keep things forever. Otherwise, there is never an end to that 3-year period. Like if I just keep a job posting forever, then I have to keep all the documentation forever. And even in this digital world, forever is a very long time. I particularly do not like this section. There's a lot about the ESA I don't like, but this one I really don't like. And why I don't like is there's a lot of personal information that applicants provide you, right? Their phone number, their address, their job history. And we're keeping all that information, not because we're thinking of hiring them, but because the law says I have to keep it for 3 years. Now, the logic behind this is that if somebody wants to complain, i.e., I didn't get this job because you don't hire women for it, or I didn't get this job because I have a disability, you have maintained the information essentially for the limitation period, right? That's essentially the logic of the 3-year period, which is typically a 2-year limitation period. And somebody asked, is keeping applications for all who applied or just those shortlisted? And far as I understand it, Christine, it is for anybody who applied. So I don't like
Wow.
this. If you look at my office, it already has too much documentation. If you look at my hard drive, it already has too much documentation. So you've got to work with your IT about how can you create a space to automatically, put all this information, date it, diarize for a destruction date, and then destroy it.
Christine
Okay.
had a quick follow up here about what about unsolicited?
Well, if it's unsolicited, I don't know the answer because it was
Hmm.
essentially triggered by the job posting. So as I said, a lot of this is going to work out. I'm going to write down that question. And so maybe we'll have to do
This
something.
feels like a whole session in and of itself,
Oh,
as
it
a
is.
matter
It's
of
like, yeah,
fact.
this
Yeah.
drives me nuts.
I do
Uh,
have a question, Nina, that I think will apply across the board, not up here, but
yeah.
because a lot of organizations are using electronic tools to organize and receive applications. Is that sufficient, or do they have to do more than what their systems are doing?
No, but a lot of those systems you have to worry about. You have to worry about whether they're retaining it for that 3-year period, and then
Hmm.
how are you going to set them up to destroy it? So I'm not familiar with the specific automated candidate management software that companies are using, but you have to
Hmm.
examine your candidate management software to make sure, yep, if I need to prove to the Ministry of Labor who applied to this job posting, what we communicated with them,
Wow.
and then the destruction setup, then I have it in this candidate management system. If it doesn't, then you're going to have to figure out a workaround with IT. And so somebody asked, well, do I can need to keep interview notes and rationale? Well, no, the law doesn't require that. But then you've got to think about whether or not you want to keep it as part of your strategy as to how you shortlisted people. Because if you are facing a discrimination case, your lawyer is going to say, well, do you remember Joseph Doe? No, I don't. Well, do you have any notes about why he didn't, get shortlisted? It's nice to have the notes, right?
Sure.
I
Yeah.
recommend you talk to your own lawyer, discuss types of recruitment that you do to determine, are you going to keep more than the bare minimum? One of somebody says, what about co-op job postings? There appears to be no exemptions for universities and colleges to this. So I think they're bound by this as well. Next slide. The other thing is new section 8.3, January 1, 2026, you cannot ask for Canadian experience. Most of you can don't do this, which
Yeah.
because you don't want to open yourself up to a discrimination complaint, because the Human Rights Act in all provinces and federally prohibit discrimination on the basis of national origin. And Canadian experience can be used, quite frankly, as a surrogate for that type of discrimination. However, if there's licensing requirements, you can't state them. So if I'm hiring a lawyer, I can state that the person has to be licensed by the Law Society of Ontario or eligible to be licensed by the Law Society of Ontario. So that does not preclude licensing requirements. And ironically, it doesn't, the law is weirdly drafted. It says your job posting can't say Canadian experience, but it doesn't actually say you can't ask for Canadian experience.
Mm,
So
interesting. We have a few questions. Did you want to cover those after you go through these?
let me have a look.
Yeah. There was just a question about permanent posting, permanent equals permanent retention
Yes,
implication.
yeah, Jennifer Farron asked that. Thank you, Jennifer. I think if you just constantly have a job advertisement, since the time is from the closing of that job posting, then I think you've got to essentially take it down or redate it so that you have a beginning and an end. Now, some people have said, well, some of these candidate management systems, somebody mentioned LinkedIn. I've never used it to source a candidate, so I can't speak from personal experience, keeps everything. But remember, it's not just the application, it's all your communication. So you may be taking things offline, LinkedIn. So just think about this. We don't have time to go through all the ins and outs of the document retention, but it's just something you want to put into your, if you say work plan starting January 1, 2026. So
There's a
talk.
really good, yeah, sorry, Nina. There is a really good question here that given all that's been, so there's a question about Indeed, I think similar to the LinkedIn. Do they need to dismiss or keep those that Christine asked? So I think that's a good question. And as you explained about the different applications, I don't know if you have anything additional to say
Yeah,
there.
there was a really interesting one that some places, um, so you have let's see, you had, people are commenting, what about, like, if you automatically reject or LinkedIn automatically rejects applicants from the wrong geography, do you have to keep it? Well, interestingly, it's if you're not seeing those applications, I think there would be a really good argument to saying, well, that we don't see that as an application because we don't see it. But if you can somehow see those, then that's an application, right?
Hmm.
I'm not,
Hmm.
um, you know, and then somebody else said, we'll say employers will say local market knowledge or existing networks may,
Oh,
may be a surrogate for no Canadian experience. We'll see how the courts and the Ministry of Labor deals with alternate, wording, right? Like, and we don't
yeah.
know that, right? And remember, a lot of this, I think, is symbolic. It's signaling to the community saying, look, we want you to be more open to newcomers. But I'm not sure if, literally, if I, say I want a marketing person who has marketed in, the KW professional community, is that going to be seen as a Canadian experience requirement,
So this is a really good question about the risk. Given all that's stated, Ian's asking here, if found non-compliant, what is the risk or exposure for an organization?
Right. So the Employment Standards Act can do a couple of things. Most likely, they can do an order to comply.
Mm-hmm.
That's the easiest. However, the Ministry of Labor does have the ability to fine companies and individuals who do not comply. And the
Mm-hmm.
fines are significant. And if I have time while you're talking, Ina, I'm going to look up the fines for non-compliance. But
Sure.
remember, this is Jan 1, 2026.
Yeah.
My belief is that the Ministry of Labor will not go guns blazing, and their focus will be on compliance and
Yeah.
encouraging compliance. So I believe that that's going to be the first issue, right?
Yeah, and someone's asking about hiring in like Canadian salespeople outside, like if they're outside of the Canadian market or hiring, sorry, specifically, oh, if a foreign company is specifically trying to hire Canadian salespeople to get sales in Canada, could they require Canadian experience?
I would be very careful. I would actually talk to their lawyer as to how to phrase
Yeah,
it. And,
yeah,
preference will be given to candidates who have an established track record in increasing sales in certain geographies, right?
yeah,
So we'll have to figure out, because I just think it's, remember, we're not precluded from having those requirements. We're just precluded from advertising them. And so,
wow,
and,
yeah.
and it's an advertisement. So we're not at the interview stage, not at the screening stage. It's at the posting stage. And then somebody asked about English fluency requirements. We have to be very careful about those, because while a certain level of literacy and fluency is absolutely appropriate for most jobs, we have to be careful that we are not requiring a greater level of English language proficiency than is actually required for the job. Obviously, if you have a university professor who is presenting, presenting all the time, that's going to be a different level of fluency that you're going to require than somebody who is a forklift operator.
What about I'm not going to be able to say this word. I don't know why it's just not coming off of my tongue today. Eligibility requirements for the job. Like if you have to have a Canadian, it feels different, but need to be Canadian citizens or have a refugee status.
Well, I
Uh,
think so. The immigration law is very clear, Amy, that
mhm,
an employer can only hire legal
sure.
somebody who's legal to work. So
Yeah.
that is
Yeah.
Canadian citizen, PR, or work permit or other status holder. So it's perfectly, but we have to be careful how we advertise it. And since that
Mhm,
is, I mean, I guess on LinkedIn, maybe it makes sense to put it in because it's an international platform. But in
mhm,
local advertising, it's understood that you're only going to offer the job to somebody who's legal to work in Canada, right?
mhm.
So
Yeah.
I'm not too worried, right? Um, and so yes.
I
Okay.
just want to say something because I know you have something to look up. But I want to say overall, if everyone is feeling a little bit overwhelmed by all of this, I don't blame you. This actually feels, especially keeping all the records. I
Oh,
hope some really smart company comes up with a sophisticated organizational tool to collect all of this because I have to tell you, I mean, I'm not, obviously love employment law. That's the podcast. I really wanted to be a lawyer actually, but I didn't have the thick skin that you have, Nina, to do it when I was younger. But today I would consider it. Although I'm too busy. But I will say that this I didn't know about all of these requirements to retain all these records. That in particular, if anyone is feeling like that is quite overwhelming, I do not blame you at all.
oh,
And and now
and I
I'm
don't
thinking, go ahead, Nina.
And I have to tell you that it really, I'm not sure let me rephrase this. When legislation comes in, usually I can say, oh, this is the problem and this is the problem they were trying to solve for. And I may agree with the solution or not, but I understand what the problem was. The document retention piece,
Hmm.
I honestly do not understand what problem they were trying to solve for. And sometimes
Yeah.
this legislation was created to say, look, we're really worker friendly and we're trying to create avenues so that we can enforce the law, but this is not what workers need, right?
Right. Yeah.
And so yes. So all right, next slide, because I do want to
So
get
we
through
have
my
we have
slide deck.
one more question in the Q&A,
Sure.
and then I'll go to the next slide. And I
Yeah.
apologize because it's a little bit hard for me to see. Is there anything that can be done as an argument as they continue to cut options for permanent residency and extending work permits? I don't know if this ties exactly to this topic.
So we should probably deal with this in a new coffee and law podcast
Okay,
or a
sure.
presentation. But I think that the underlying concern, let me tell you about the old way, okay? When we were hiring before, let's say hiring before 2025, and we got a candidate that had a postgraduate work permit, usually between the degree, the postgraduate work permit, we could
Hmm.
see that somebody had a pretty secure pathway to permanent residency,
Hmm.
right? We now have found out not only with postgraduate work permits, but in general, Canada the um, has tightened the pathway to permanent residency, and work permit extensions are also more difficult. And so the question is, you're essentially looking at a resume. You can't ask for Canadian experience, and you're sort of saying, this is sort of my preferred candidate, but I don't know how long this person will be able to stay in Canada and work.
Hmm.
I would say that that is an interview stage discovery process. And since this is really focusing on some changes around year end, I want to move on. But what I would encourage people is to talk to their employment lawyer as to having those candid conversations in the interview stage about expectations regarding how long this employment is for, if things work out, obviously, and work permits and extension of work permits. And Amy, you've met my immigration colleague, Bill
Yes.
McGregor, and
Yeah.
he is increasingly being asked to give guesstimates as to whether or not somebody is likely to get an extension or a PR status, because obviously if somebody's work status is going to run out in 6 months, that's not a good hiring experience for anybody.
Absolutely. There's a really good question in here. Thanks, Shweta, because this is all about AI disclosure. Because a lot of companies
Okay,
are
we're going
using.
to get into
Oh,
AI
sorry.
disclosure,
Okay.
so if we could
Stay
just move
tuned.
on. Yeah, yeah,
Okay. I've been told.
you've been told.
Yeah.
So the other thing, again, for 25 employees, and it's Ontario legislation, although other provinces have similar legislation, particularly BC, that has been a leader in this. And this is any external job posting for a specific job, right?
Mhm.
Excluding help wanted signs in the window, like in the right. Um, you have some specific obligations regarding pay transparency. Now, this is pay transparency light. Okay. What do I mean by that? Next slide. First of all, it's really a disclosure requirement on the ad, and you have to advise of the compensation. And many of us have ranges, right? So, for example, even some of my hourly unionized workers, the range might be 21.20 to 25.20 plus some shift premiums. So you have to disclose that, and the range of compensation cannot exceed $50,000, because a lot of people
Mhm.
were trying to say, oh yes, this job is between 105,000 and 700,000. Well, that doesn't tell anybody anything.
This actually feels like it's a good idea because it saves
I
a
think
lot.
so.
Like I feel like this is a mutually benefit. People can disagree with me in the chat, of course. But I do feel like it's a mutually beneficial. You don't waste the employer's time, you don't waste the candidate's time. Everyone sort of has a sense of what it is going into the interview.
Yeah. And so yes, I think it is. And I remember, this will be over two decades ago. And there was a in-house position that honestly was perfect for me. And I applied for it. And the recruiter came up and said, look, you're perfect, but I want to be very clear that the salary range is X. And
Mm.
um it was 35% less than what I would, maybe even more. It might have been 50, yeah, 35% less than what I was earning at the time. And I just couldn't take that cut, right?
Hmm.
And
Hmm.
so I said, look, I'm not proceeding. Now, if they had already advertised it and said the range for this position is, 100 to 120, I wouldn't have even bothered applying and they wouldn't
Yeah,
have wasted their time. So I do
yeah.
think it's good. It's also been scientifically shown that women are less aggressive in general about asking for what they're worth. And so having that as this is our range for the job, many employers used to say, well, I'm going to pay whatever they can negotiate, right? And
Hmm.
so the so yeah, and so if somebody's not as good a negotiator, women typically are shyer negotiators. They're going to pay less, while somebody new who's a stronger negotiator will get paid more. Pay transparency, pay equity, equal pay for work at equal work are all methods that the courts and tribunals are using to try to make sure that the gender gap is reduced. One big exemption is anybody where the range ends at an amount equivalent to more than 200,000 annually. Okay. So a lot of senior managers, executive and professionals, it's not just base salary, it's bonuses, short-term incentive, long-term incentive, anything that you would be considered as wages will be included in calculating that range. And if you think someone's going to earn more than 200K annually, you do not have to disclose. All right.
We have a question about, is this what is there something that was supposed to be implemented in 2019 on January?
Ah,
We have
that
someone
whoever
who's
asked that question
Terry.
is going to get a gold star from me.
Well, Terry's awesome, so I'm
Okay,
not
Terry's off.
surprised.
So this is the light version of what the Wynne government, for those of us have political memories back 6 years, was seeking to had enacted but not promulgated into law. In other words, it had passed the legislative process, but they hadn't set a date for it in 2018 or 2019. So, but this is a lighter version, and the previous legislation, I think, was actually probably more effective with respect to requiring more transparency. So this is pay transparency light. All right. So next slide.
Oh, well, can I ask one more question that's in the chat here, or in the
Yes.
Q&A actually, because I think it's an important one right now. Our friend Amy asks, what is the best way to handle disclosure of variable comp in a sales role where commission is not capped and there is a true unlimited earning potential?
So I've been struggling with this, and I wish the government
Yeah.
had given some guidelines. So what I ask my clients to think about is, if, like, let's say there's a base plus commission. And although theoretically there is no top line, um, we can sort of say, well, a decent performer usually ranges between X and Y in commission. And
Mhm.
that's what yes, I mean, you may have the superstar, you may have the Otani of salespeople, and they're going to just hit it out of the ballpark and there is no cap. But I think that, like really what people are attracted to is, what is my likely earning potential? So I would work on the phrasing as something, base of X, commission plan that's not uncapped, usually in the range of 25 to 50,000 per annum, right? Something like that.
Mm.
Now, if
Mhm.
all your salespeople are really, remember, it's where expected compensation is over 200,000. If your regular performers are, definitely hitting that 200,000 and more, I think you have a real good argument to say we don't have to disclose because the expected compensation typically exceeds over 200,000. And Swetha has had some great comments. I want to give her a shout out where they say, I wish they outline who gets the top dollar and provides transparency.
Mm.
I think that I went to a seminar yesterday, and that's what people say. If you say the range is 100 to 120, people are going to say, well, I'm really good, I should get 120.
Mhm.
But really that 120 is for people who've got perhaps 5+ years of experience in the position, really great numbers. And I think that, remember, this is at the job posting stage. A lot of transparency can be provided during the interview and the shortlisting phase, right?
Yeah.
All right, next slide.
Okay.
Artificial intelligence. Okay. Again, if you have 25 people or more and you're using AI in job posting, so artificial intelligence is defined in this case as machine-based systems that generate outputs such as predictions, recommendations, or decisions based on input, which can influence the physical or virtual environments. And some of the search engine optimization and techniques we're already using would have to be disclosed. And many of the platforms, including LinkedIn, which was mentioned by one of our uh, participants, already is using AI. And
Mhm.
so you have to disclose in your job posting, if you're 25 and over, whether or not you're using AI. And the vast majority of people who are here are probably, if they're using LinkedIn or one of the other platforms, likely, they should check it out, are probably using AI. And so all you have to say, you don't have to say how you use it, but you can
Mm.
say something like, we use AI to, or we use programs that use AI to help screen and rank applications, period. I can work, you'll work out your wording as to be most accurate, but you have to disclose it. So we have two disclosure, new things that you have to say in your job posting. One is the range, if it's under 200,000 dollars, and that range has to be less than 50,000, the bottom and the top. And then two, whether you use AI, and if you're not already using it, I'm expecting that you will be using it in 2026.
Yes.
All right, next slide. Oh, the third thing that has to be disclosed if you're over 25 in your job posting is whether or not there's an existing vacancy. So this, I think, is to try to cut down on people who just advertise to see what is out there, and are not really serious about recruiting. I'm not sure how big an issue it was, but so if you have an existing vacancy, you or whether or not it is, you must confirm whether it's an anticipated or existing vacancy, or whether or not you're just recruiting to fill a pipeline. So that's number one. Secondly, so that's the first thing. So we now have three things extra that are going on your job ads, right? It's your job range, whether you use AI, and now whether it's an existing vacancy or
One very quick question on AI,
yeah.
just because I see it and it's a good one. Is resume parsing, does that count as AI use?
You'll have to like what sort of like algorithms that are used to sort
Yeah,
of,
I guess
yes,
they're sorting out
absolutely.
resumes. Yeah,
Hmm.
that's what I figured as
Yeah,
well.
absolutely. Yeah.
Yeah.
So I hadn't heard it phrased that way, but yes, for
Mm-hmm,
sure. Because
yeah.
if it's
Mm-hmm,
reviewed, yep, that's
mm-hmm.
for sure. part of the AI. So those are the three things. Now, assume you have this job posting and you start to interview. Anyone who is interviewed must be advised within 45 days whether, quote, a hiring decision has been made. And that can be done in writing, in person, or using technology. But I'm going to say do it in writing, including email or text, because remember, this is part of what you have to, it's whether a hiring decision has been made. And remember, you have to keep this communication as part of that 3-year rule. And what is an interview? It is everything excluding communications, meetings in person or virtually, to assess suitability, excluding initial screening. And, like I'm just telling people, look, if you've got different screening methods, I think you should be shouting at the top or, putting in bold. This is not an interview. This is just an initial screening. Or if you're a recruiter that is helping with this process, then you need to say, look, this isn't a full interview. This is just a basic initial screening just to make sure that, you're eligible. Make sure we distinguish clearly when that interview clock starts running. Okay. Somebody else says, oh, I'm just going to be like my teenager and seek forgiveness. I don't blame you for that because I don't know how much the Ministry of Labor is going to go after us for every single one of these new obligations. Next slide.
It does feel like a lot all at one
It is
time.
a lot, all of them.
Yeah.
Okay, so I'm going a little bit back in time. Again, if you're over 25, there are a whole bunch of things that you should be providing, required information. And this was really designed by fly-by-night companies that were preying particularly on newcomers. So every employee needs to be given the legal name, operating name, contact information, work locations, clear starting rate of pay, pay period, hours of work. Now, there's some exemptions for temporary employees that are placed by agencies or assignment employees. Look, if you've got an employment agreement, it'll be all there. If you have an
Mhm.
offer template, it's all there already, or it should be. But this is now mandatory. And some people that are in a more informal hourly work setting, there's just doing a one-pager with all the requisite information that people get during the onboarding. You've got, I think, 30 days from the start of employment. I believe all of this should be given before people start. All
Mhm.
right. Okay. As you know, Amy, we have lots of homework to do. One of the things that people forget is the annual review obligation on occupational health and safety. Now, I realize that occupational health and safety sometimes is dealt by OHS professionals and specialists as opposed to HR specialists. But in many companies, the HR specialist or HR person is the chief cook and bottle washer. They do absolutely everything. And so I wanted to remind people that your OHS policies need to be reviewed annually. And while this is an Ontario piece of legislation, this is a great idea for anywhere that you operate. And that in Ontario and throughout Canada, that OHS policies include your workplace violence and harassment policies. It includes your program, like not just the we are against violence and harassment, you can't do it, but also how do you deal with issues of harassment? How do you process complaints? How do you investigate them? What are the potential consequences? How do you train people? All of that's part of your program. So that should be looked at once a year, and you should be getting the help of your Joint Health and Safety Committee. So if you haven't done your 2025 review, and as Amy pointed out, 20 shopping days to Christmas, it may not be something you get done in December, but put it over and make sure you get it done in January so you can have a recent. And I also recommend that for those of you, it's not all of you, but some of you are working with hazardous materials, and that could be something as seemingly innocuous as cleaning supplies, just making sure that workers are truly familiar with the potential consequences of cleaning supplies. Just because it's ubiquitous doesn't mean it's safe. So
We
that's
have
your,
a really
Go
We have
ahead.
a good question here. What do you suggest for remote companies regarding OHS policies? We have violence and harassment policies, however, hazardous material, etc., feels irrelevant.
Yeah, I'm not like so I do have clients that have occupational health and safety for remote workers, and it's a single worker and they're largely a desk worker, a knowledge
Mm-hmm.
worker of some sort. But you still have occupational health and safety obligations, including ergonomic desk, safe workspace. And then if I put my other hat on, I'm always concerned about things like confidentiality and document retention and
Mm-hmm.
privacy. So, really what you do is you create a policy for your for health and safety for your remote workers. The Canadian, it's called, I think it's CCOHS, and I can never remember what it completely stands for. But it's like the Canadian Center for Occupational Health and Safety has a telework policy, which I think is so quaint. But effectively, it was started in an era where literally people were working by remote telephone.
Oh
I think our
God.
technology has improved. And
There,
so,
go ahead.
uh, yeah, so, but ergonomics matter. And some of you will laugh, but so during COVID, several of my legal clerks and assistants complained that they were physically feeling really drained because they didn't have the proper desk set up. They didn't have the nice Herman Miller chair that, they had
Mm,
here. And, um, I'm a believer sometimes, especially when you're trying to do the right thing, to do first and seek permission later. I got into the office because I'm a partner. I still had access to the office. And my husband has a Ford F-150, and we stole the
mm,
chairs and we stole the second screens that they needed and we stole the mice. And I essentially, like safely delivered it at 6 feet because I could see that my clerks were physically hurting
mm.
because they didn't have the right equipment. And I assure you that nobody at Gowlings, complained or put me on disciplinary review for it. But it was because we thought of remote work as safe and safer than being out in the workplace where there was a COVID transmission risk. But nobody was paying attention because our policies, our health and safety policies hadn't caught up with this new brave remote work environment. We're much better
Mm-hmm.
now. Like
Hmm.
we're way
Oh, well,
better.
I mean, no one would have caught up at that point, of
No.
course, right? But it's great that you got ahead of it. You're just reminding us why all of us, you're so wonderful. And that's
Yes,
like just one
exactly.
example of. Now, there's a question here about is this uh, so is this applied to the annually reviewing the workplace violent risk assessment as well?
Yeah, that's part of that, right?
That's part
That's
of it.
part of
Okay.
it. But it's also your regular occupational health and safety, your
Hmm.
machine guards, your training, your lockout, tagout policies and training, all of that. Now, not everybody has it, Amy. I'm
Yeah.
thinking more of a manufacturing setting or a distribution and packaging setting, but you need to think about all of that on an annual basis. And okay, Anesha, you're right. Okay. You're right. You catch me on the Otani thing. I still think he's amazing, but everybody else is a Jays fan, so my apologies to the audience.
There's there's a
Uh,
question here from Level, high level. Good to see you. About what happens if an employee is coming down the stairs during their work shift and they fall and they're a remote worker, but they've done that at
yeah,
home.
so we haven't thankfully had a lot of claims like that.
Hmm. Hmm.
And there's a couple of reasons for that. One is many of the remote workers work in industries where you're not a mandatory WSIB employer, right? So if
Hmm.
you think about a law firm, we're not a mandatory WSIB employer, we're exempt. Two, there is some case law where they try to say, well, was this in the course of work? In other words, did they trip over the extension cord as they were reaching for a work phone call? Or were they going for lunch or throwing a
Hmm.
load of laundry in? Why were they upstairs? So the WSIB and will look at whether or not it was work related or not. But also, when we're doing our, like review, I'm not saying that we need to go into everyone's offices. It's good to have a checklist.
Hmm.
Let's avoid tripping hazards. I have one lady that would just essentially get you to use your little camera that I have on top of my computer to just do a quick sweep of the work area just to make sure there's not a lot of tripping hazards. And I'm a bit of a sprawler. I do have piles of books here and piles of paper there and my shoes over there. And she essentially quietly said, you might want to tidy up a little bit. You wouldn't want to trip, and that was it.
Yeah.
Went through one ear and out the other, but
Yeah.
it's good advice. All right, next slide. Other policies, if more than 25, there are two policies that came in under one of the Working for Workers Act. One is the right to disconnect, and one is the electronic surveillance policy. I recommend actually you review both because as new technologies arise, you may need to update one or both of those policies. And there's no annual review that's required, but if you find, especially the electronic surveillance policy is a bit obsolete, if you do update it, make sure that a copy of the new policy is provided to your employees within 30 days. Remember, the Act does not stop you from using surveillance on your employees. The Act does not give employees a right to disconnect. It's just you have to have a policy. And the policy, as one of my colleagues has pointed out, could be, the right to disconnect policy is if you work for us, we can reach you 24/7, 365. That could be your disconnection policy, but you still have to have the policy, right?
This is an interesting one. I just want to add here because that's something that uh, not everyone might know in the organization, and IT changes something. So that just as a little heads up, I'm sure you give this advice to your clients. It's like, make sure your organization, the key people in your organization or teams are aware of this requirement because things are all happening all over the place that the person doing the annual review is not necessarily going to understand or know about.
Yes. And that I just wrote a memo to a client of mine where I made the same point is I'm not sure that everybody who needs to know is aware because of the way information flows,
Hmm.
right?
Yeah. Yeah, of course.
And that's often an issue. It's not just an issue with respect to these policies. It's often an issue as, when we're coming up to termination decisions and the person who's looking at a spreadsheet may not be aware that somebody is expecting or is just coming back for leave.
Hmm.
Not be aware that there are performance issues because those performance issues haven't percolated up to HR. So yeah, information flow is a really important.
I'm gonna tell you something that's gonna shock everyone right now, Neena. It's 1:57.
Oh
I
dear.
haven't done a very good job of timekeeping. I don't know if we're on our last slide or where we are. But there, look, you're so good, Neena.
There you go.
Well, make sure that you reach out to Neena. Like, I'm so happy for anyone who doesn't know this story. Neena and I originally connected through LinkedIn, and you see us here, but we have a personal friendship now, which I'm very happy about. Like so many people, many of which are on this call today that I've connected with on LinkedIn and met in real life or had real interactions with. So yeah, I think you're a great person to reach out to. As I always say of you, Neena, you're the person I would want on my side if I ever needed anything.
Well, I'm
Um,
really hoping that, I like doing the advisory work, keeping people out of trouble. We are in early days with the pay transparency and document retention requirements. So there'll be lots of clarification coming from the government. I think
mhm.
we just have to try to do our best, quite
Sure.
frankly.
Yeah, absolutely.
And I have no doubt that it's my belief that the Ministry of Labor will be understanding if they see a good faith effort to comply,
Hmm.
right?
Yeah, yeah. Well, with that, I want to thank everyone for all of your engagement in the session. I know there was a lot of questions in the chat, and I apologize. I could only myself keep tabs on the Q&A. I know, Nina, you always impress me because you're typing answers, you're seeing answers in the
I'm
chat,
trying
and
really
there I
hard.
am doing nothing but looking at the Q&A. But I want to wish everyone a very, very happy holiday season. You will get more information from me. I'm going to send you a little bit of information this afternoon as a follow up. Next week, I will send out the recording of this session. I'm going to be asking you in the new year. I'm going to send out a message for you to fill out a form where you can tell us more about some of the topics you might like to see, both for these webinars and for the podcast. But Nina, as always, you're amazing. Thank you so much for being here and joining us, and sharing your wisdom and experience, and not your legal advice, but your, updates with everyone today. So I really, really appreciate you, and I appreciate you doing this session. And I'm sure I'm seeing a lot in the chat. I'm sure that everyone in the chat or and on the call feels the same way.
An excellent engagement on the webinar chat. Like I saw people
Yeah,
share resources and links to
great.
legislation, and Sarah Gower, found out the link to the CCOHS for me. Thank you very much. And I want to really tell you that even though we can't address all of those comments, really appreciate it because we're trying to replicate the joy and the excitement we get when we meet in a room. So I
Yeah.
too wish you a happy holiday. I also wish you a great 2026, and I look forward to reconnecting with you in the early new year.
Thank you, and thank you, everyone. I'm going to awkwardly stay on the line here just to make sure I get our little, uh, all of the little recordings and everything that we need. Uh, but as always, Zoom is just not cooperating. You'd think I would be a Zoom expert at this point, Nina, because there we go. Because
I would think so. And we are getting better, but yes,
yeah.
it takes a little bit of time. So, be patient with yourself.
I know I should be. And it's always like everything, like the law, it's always changing. Well, listen, with that, I'm going to say goodbye. Thank you so much. And see you in the new year.
See you in the new year.